Hello, everyone. Good afternoon. My name is Gigi Maja. I am an advocate and a practitioner in law in Tanzania and in Zanzibar. I practice in both jurisdictions. I'm also an accredited mediator, negotiator, and arbitrator. And I practice with a law firm called Rex Advocates, and I'm based in Dar es Salaam. For those of us who had joined us at the first part of this webinar, this is a series of webinars, and our presenter will be the same person, the same expert from last time. For the benefit of those that had not joined us at the last session, I'll just very quickly give an introduction to who he is. So our presenter today is Mr. Lawrence Dinga, and he's a seasoned consultant with a wealth of experience in cybersecurity, in digital services, in cybercrime investigations, and cyber capacity building, as well as digital forensics. Lawrence is what they call a digital forensics expert, and he has testified in a lot of cyber security related cases. Currently, he's a consultant, an international consultant for the following organizations. The Cybercrime Program Office, this is for the Council of Europe. The European Union Agency for Law Enforcement Training. This is on cybercrime and attacks against information systems. Also for the Council of Europe in the capacity building for legal professionals for conducting research, assessments, and reports for projects. He's also an adjunct trainer on cybersecurity and law at the Kenya School of Law. His qualifications are immense. He has a master's in science degree in forensic computing and security. This is from the University of Derby in England. He also has an LLM in ICT law from the Open University of Tanzania. He has a diploma in law from the Kenya School of Law. And he's also a CISSP, which is a Certified Information System Security Professional. Now, for those who joined us at the first session, in the first part of this series, Lawrence introduced us to electronic evidence, into the characteristics for electronic evidence, the sources, and he helped us to look at the principles and the best practices in handling electronic evidence. In this session today, Lawrence will be discussing the processes and procedures for conducting digital forensics, and he'll be showing us how to present legally admissible digital evidence so that it meets the threshold to be used in courts of law. Lawrence, if you'd like to take it away, please.
Thank you, Gigi. Let me just share my presentation.
Thank you. Lawrence, while you're doing that, can I just quickly add, for the participants who are in the session, should you have any comments, please put those in the chat. And should you have any questions, please put those in the Q&A section. Thank you.
Can you see my screen?
Yes, Lawrence, I can.
Okay, thank you very much, Gigi. Today, we want to look at the analysis and presentation of legally admissible electronic evidence. As you know, electronic evidence is not like the physical evidence, and there are certain principles that you need to look at when you are handling electronic evidence, and that is what we looked at in our last session. So just to recap on our what we looked at in our last session, there are some challenges when you're handling electronic evidence, and one of the challenges is we say that it is invisible to the untrained eye, which means that this electronic evidence, it's found in places where only specialists would search, and in locations which are reachable only by means of special tools. So if you do not have that training, that expertise to extract electronic evidence, it will be very, very difficult. So that is one of the challenges of digital electronic evidence. Now, it is also volatile, means that electronic evidence can quickly disappear just by being overwritten or by being deleted. And that happens quite a lot. You find that somebody may be able to mistakenly delete information from the computer. And also, when you get, let's say, a device, electronic device, which is on, it has memory. And this is what we call random access memory. Whatever is stored in random access memory will be lost if the system is shut down. So that volatility must be observed by the person who is actually doing the investigation. Electronic evidence is also fragile, which means that it is susceptible to alteration, can be easily manipulated, altered, or damaged. And this can be intentionally by the criminal because they know they will get caught. So the process of collecting electronic evidence must therefore be methodical and must be systematic, so that you are sure you collected the real evidence that you are looking for. Now, electronic evidence can also be duplicated without degradation, and each copy will have they will be the same as the original. So electronic information can be copied indefinitely, with each and every copy having this exactly as the original. And this one we looked at when we were looking at introduction to electronic evidence. And we say that this copying is not just the normal copy and paste, is what we call bit by bit copy of the evidence, so that you can actually analyze the copy of the evidence. Another challenge is that electronic evidence, when we look at globally, it is transborder. It is possible for a criminal to be in one country and the crime to happen in another country, and the evidence to be held in yet another country. So that transborder nature of the electronic evidence makes it a challenge to acquire it properly. Now, also proper procedures, techniques, and tools must be used. So as more traditional forensic discipline, digital forensics specialists require special tools and knowledge to undertake their investigations properly. Then the last challenge is the admissibility. Electronic evidence must be obtained in compliance with the existing legislation and best practice to ensure admissibility at trial, which means that if you don't collect this electronic evidence in compliance with the existing legal legislation in your country, then that evidence will not be admissible in the court of law. Now, let's look also, this is a recap of what we did last time. Let's look at the admissibility of electronic evidence. How will you make sure that the evidence that you present in court will be admissible? Now, electronic evidence, first of all, as I said, it must be collected in compliance with the existing national legislation and best practice to ensure admissibility at trial. That is very important, because if you do it without a legal authority, then automatically that is going to make that evidence inadmissible. Now, one thing that you need to look at is that when you are going to present that evidence, when you are going to collect that evidence, you must have the legal authority. The legal authority can be in terms of search warrant or Anton Pillar, and so that when you present it to the court of law, then that evidence will be able to be admissible. This is the concept of fruit of the poisonous tree. If it's not legally collected, then it is not legally admissible. The other thing that you need to look at is authenticity. It must be shown that the evidence is what it purports to be. Authentic means that it is genuine and matches the claims about it. So if you are collecting evidence and presenting it in court of law, are you able to convince the court that this is the exact evidence that I collected and nothing has changed? It is what it purports to be. So authenticity is very important in collecting digital evidence. Relevance. Forensic relevance is determined whether electronic evidence will establish a credible link between the perpetrator and the target or the crime scene. I think that is self-explanatory. So there must be relevance in that electronic evidence. Integrity. Integrity is something which is very, very important when you're talking about electronic evidence, because there must be a proof that electronic evidence has not been altered either intentionally or unintentionally. Now, the reliability. There must be nothing in the way in which the evidence was collected and subsequently held that can cast doubt on its authenticity and veracity. Now, if you want to establish the reliability of the electronic evidence, then whatever you go to court and to defend that evidence, you have to show that when you are collecting this evidence, there must be an audit trail that showed how the process was done, how the copying was done, so that the court can believe that it is reliable. Then there's credibility. Credibility is a measure of a witness and whether or not that witness is worthy of belief. As a witness must be considered credible if they have reliable information about an event. Now, to establish this credibility, now the person who was doing an investigation might be required to testify in court about his qualification as an investigator, the standard that he employed, the tools and the procedure that he used to collect and analyze the evidence, and the method in which that evidence was preserved, and the qualification of the people who are actually doing that analysis. That must come out very clear in the court of law, and that is why, as an investigator, when you go to court, you will always be required to have a certified copies of your certificate, just to show that, yeah, I'm somebody who is credible, I'm somebody who has got the knowledge and the skills to do this job. And then the last one is the validity. The validity is one way to demonstrate electronic is reliable is by showing that it was collected in a valid manner, whether the scientific principles were used to preserve, to acquire, analyze, and electronic evidence, and the standards were met to handle and examine electronic evidence. So those are things that you need to put into consideration when you are presenting the evidence, electronic evidence in the court of law. Or if any of them cannot be proved, then that evidence might not be admissible in the court of law. Now, what is let me just, this thing is, let me just try to arrange my screen here. Is
okay, Lawrence.
Don't know how to.
Are you trying to go to the next slide?
No, I'm trying. There's this bar which is up here, which is making part of my screen not to be seen. Disable.
Okay, you can make it not be a full screen. You can wait, hold on.
Let me just
try your view options. You can exit full screen and then come back.
Let me just okay, disable. Okay, but you can see my screen is okay.
Yes, I can see a screen.
Okay, so I think we've looked at what we need, you need to make sure that the electronic evidence that you are presenting in a court of law meets those thresholds so that it can be admissible. So let's look at the digital forensics, because for you to extract that evidence and scientifically, that process is what we call digital forensics, because digital forensics is what is going to allow you, the process that is going to allow you to actually collect and analyze electronic evidence in a scientific manner so that it can be admissible in the court of law. So what is digital forensics? Now, digital forensics is a branch of forensic science. It's actually a young member of forensic science, and it involves methodical application of computer investigation and analysis techniques to gather evidence found in computer and other electronic storage media. Now, it involves the use of modern technology and procedures to identify, preserve, and analyze electronic evidence in a manner that is legally admissible in the court of law. So what we can say that it is not only a process, it's not only a tool, it's also a process and a procedure. And the process must be scientific. So what we can say is that digital forensics is actually the convergence of science and law, where we know that you are actually investigating and collecting the electronic evidence with an aim of presenting that evidence in the court of law, even if it's a corporate investigation. But you have, as an investigator, it must come into your mind that this evidence might find itself in the court of law. So that is what we call the digital forensics process. Now, just to expand a bit, this diagram here shows the digital forensic and its branches. Now, you can see up there we have computer forensics, we have mobile forensics, we have network forensics, and we have embedded forensics. Now, in computer forensics, here, this is the oldest branch of digital forensics. It used to even be called computer forensics, but it was changed to digital forensics when so many devices that can carry data came, the technology expanded. So we could not only, we were not only examining computers for evidence, but any other devices, things like the cameras, things like the mobile phones. Now, that is why it has digital forensics covers all these devices. So in computer forensics, which is the oldest, we have what we call postmortem forensics. Postmortem forensics is where you go and have a device or a computer which is off, and you want to extract evidence from that computer, which means where is the evidence stored in a computer which is not turned on, or basically that evidence is stored in a on a hard disk on that computer. So what you'll do is that you'll take that off that hard disk, then analyze that hard disk to see if you can get some evidence from it. Then there is also what we call live forensics. Live forensics is where you go to a place and that computer that is a suspect that you wanted to analyze is actually on, and you cannot turn off that computer and take it to the lab. So it forces you that you need to collect evidence when the computer is still on. Now, this means that you'll have to, if it is you want to copy the hard disk or do bit by bit copy of the hard disk, you'll have to see how you can copy that when that computer is not shut down, the computer is on. That is what we call live acquisition. But also, you remember that sometimes we talked about when the computer is on and there's something which is running and it is in in memory. So there's some data in memory. So you need to also collect that data before you shut that down that computer. We have multimedia forensics. We have physical recovery, where you recover information from disks. Application forensics, where you can get information or data from various applications and other devices, things like the gaming consoles, the Xbox, all those things that have got data. So that is part of computer forensics. Then we have mobile forensics. Now, mobile forensics here is where you are dealing with mobile phones. And nowadays, and the process of extracting evidence from mobile phones is quite different from the process of extracting data from computer. So there are different tools that you are going to use, even though some processes might be the same, but basically there are different tools that you are going to use to collect evidence from mobile forensic, from mobile phones. So doing that is what we call the mobile forensics. Now you can do the physical extraction and analyzing that data. You can do also what we call logical extraction and do analysis, or you can use things like the wearables, other devices, all that fall under mobile forensics. Then we have network forensics. In network forensics, here is where you are capturing the data from a network. For example, if you have a local area network and there's something has happened and you need to collect that information, that is what we call network forensics. And you can do live network forensics, in which you connect your forensic workstation on the network and collecting the data that you are looking for. That is what we call live network forensics. And what you're doing is that you're just capturing the data, the packets as they travel through the network, and then you can analyze those packets to see what evidence is there. Then also you remember that when there is a malware is just a short of malicious software. Malicious software, normally when they infect your device or your network, they rarely get stored on the hard disk, but they are always stored in the memory, because when it is stored in the memory, and that particular device is turned off, then which means that you cannot be able to get the data or information about that malware. So malware analysis is also part of the network forensics. Then we have embedded forensics. And embedded forensics here is where we have the IoT forensics, the Internet of Things. Because anything that has got intelligence in it and can be able to connect to the network, to the internet, that is the Internet of Things. And that you also have a plethora of data that you can get from that. Then smart home forensics, we have automotive forensics. So you can see the world of digital forensics, as it started with computer forensics, has actually expanded, because each and everything now gets connected to the internet. And when they get connected to the internet, which means that there must be some data that you can collect from that particular device. Now, let's compare what we call analog versus digital forensics. Now, in analog forensics, for example, in analog forensics, you've seen something like this. You have to secure a crime scene. Now, in this, you can see the police and they do not enter this crime scene, do not cross this path. So that is in a physical or the analog forensics, you will always do this. Now, also, it's similar in digital forensics. Now, in digital forensics, you also need to secure the crime scene. And when securing that crime scene, you'll have maybe a computer, and this computer might be the computer that was used to commit the crime, or it must be a computer which is just used to store the proceeds of crime, things like the sales of drugs, Excel worksheet. So it becomes an evidence in your case. So as much as you can see, analog forensics has got securing of the scene. The same thing happens in digital forensics. Now, if you go to a crime scene in analog environment, you'll always try to put your gloves. Why? Because you do not want to contaminate the crime scene. So what does this glove do? The glove will prevent you for your fingerprints to remain on maybe the murder weapon, or if you are going to maybe a door that you are going to enter, you don't need your fingerprint to remain there, because when it is dusted, then it will be able to find your fingerprint there. Or sometimes your DNA also, you don't want it to remain on a device. Now, the same thing happens in digital forensics. In digital forensics, you do not want to contaminate the evidence. So if you go to a place and you've taken a computer, or you've taken a laptop, and you want to analyze this laptop, what you don't want is that you are going to collect data from this laptop, and that when you are collecting that data from that laptop, you need to connect it to a forensic workstation, or the computer that you are going to use to analyze that data. But what you need to do to prevent is the suspect. You want to copy the suspect computer. You want to copy the data from the suspect computer right into the forensic workstation, or the computer that you are going to use to analyze it. But you do not want the data from the computer, the forensic workstation, back to the suspect hard disk or suspect computer, because it will contaminate that environment. So you can see that this device here, this is what we call hardware write blocker. It blocks the signal that will make the data be copied from the forensic workstation back to the suspect hard disk. We've also seen this always in an analog environment. That is the footprints. Footprints shows you a lot of things about that crime scene, and you can analyze the footprint to find the culprits. Same way in digital world, we have footprints, and this is digital footprint. When a suspect visits our website, there's some information that is going to remain on the on that particular device. That kind of information is what will actually help you do the investigation and find some evidence that you are looking for. So each and everything that you touch, which is electronic, will always leave a digital footprint. You can see that both analog and digital world, this element of footprints is there. Now, the other thing about analog and digital world is we've seen fingerprints. Now, fingerprints, each and every person in this world has different fingerprints. There are not two people who have got the same fingerprints. So when somebody commits a crime, and then the investigators go there, they'll pick fingerprints, and then they'll dust for the fingerprints, and then they look at their database. And if that fingerprint is found in their database, automatically they're going to get the culprit, because any fingerprint two fingerprints are the same in the whole world. Now, also in the digital world, we have what we call a digital fingerprint. And this digital fingerprint, which means that each and every file that you are looking for in evidence, as evidence, will be different from any other file. So that is what we call, you use a technique called hashing. Hashing is just a mathematical function that you perform on a string of data, and it produces what we call a hash value. Now, hash value, if you go and change the original evidence, then the hash value will automatically change. So you'll know that somebody has interfered with evidence. And you can, there are techniques that I used to do this. There's something called MD5, SHA-1, SHA-2, and SHA-512. Now, if I'm presenting any evidence in the court of law, I must prove that this evidence has got integrity and that evidence has not been changed, because when I collected evidence, I calculated what we call the hash value. And that is why when I give you, maybe I do something and I give you a report, even if it is a picture which is counting as evidence, then below that picture, I'll have calculated the hash value. So to show that this is original evidence and it has not been changed. And if it is changes, then the hash value will change. And this is very important for integrity of digital or electronic evidence. Now, what is the digital forensic process? Now, if you can see that down here, I have that diagram which shows the acquisition, processing, analysis, and presentation. Now, those are the 4 steps in digital forensic process. And I said digital forensic process is a methodical and scientific methodical to extract data from digital devices. Now, electronic organizations have developed their own national guidelines and procedures for acquisition and protection of digital evidence. But because this creates an issue, let's say if you have your own process of doing digital forensics, and the other company has got their own process, this will end up creating an issue when it comes to cross-border crimes, because we need to do to extract evidence, and that evidence, if it has to be used across the border, then you'll find that one country may have a different way of doing it. So this will present an issue, cross-border crimes, because since digital forensics evidence acquired in one country may not be used, may need to be presented to another country. So if it is to be presented to another country, do we have a standard way of doing of digital forensic process that we can rely on, so that we know that we can even exchange our digital evidence? Sorry. Now, the ISO came up with what we call ISO 27037, which is describing digital forensic process. Now, this was created just to ensure that the evidence, the process of collecting evidence, can be universal and can be used across multiple jurisdictions. So you can see that in ISO 27037, it only addresses up to preservation of evidence. So it starts the process with identification of that particular evidence, then collecting that evidence or acquiring that evidence, and then you preserve that evidence. Then you can analyze. So when it comes to analysis, you can use different tools to analyze that. So the fundamental purpose of ISO 27K digital forensic standard is to promote a good practice, methods, and processes for forensic capture and investigation of electronic evidence. So that is why it was created, just because we want promote that standard. We want to promote that universal process of collecting digital or electronic evidence. Now, the first process in ISO is the identification. Now, in identification, this process involves the search for, recognition, and documentation of potential electronic evidence. Now, during this time, the investigator learns what type of electronic data and devices that must be involved in the investigation. What do we mean here? You, as an investigator, you've gone to a crime scene. And when you go to a crime scene, remember, when you go to a crime scene, you need to also have your legal backing. That is, if it is a search warrant, because you are going to collect this evidence and take them for analysis. So when you go to the identification process, just involves looking at the crime scene and seeing what kind of electronic data and devices that are involved. Now, once you know the kind of the devices that are involved, if it is, let's say, mobile phone, you are going to collect laptops, you are going to collect desktop. You know exactly what type of electronic data and device that are involved in the investigation. Then having known this, it will also allow you to plan for the tools and techniques that you're going to use for in the subsequent stages, which means that which tools do I need? Do I need software? Do I need a software to investigate a mobile phone, which is different from a software to investigate a laptop? So you'll have the collection of what tools you need to have during identification. Now, and also it allows you to avoid collecting unnecessary evidences for presentation, for analysis, because I mean, analysis can also take time. So you only want to collect the evidences that will actually, you think actually has got the data you want. Now, after that, you do what we call collection. Collection is the process of gathering items that contain potential evidence. Now, once you gather them, you transport them back to the forensic laboratory or any other facilities for acquisition and analysis of evidence, which means you just collection, making sure that, yes, my search warrant say that I'm going to collect 2 laptops, 2 mobile phones. You're just collecting and then presenting that in the, taking them to the lab for acquisition and analysis. Now, the investigator must have the legal authority to acquire and collect the evidence, and because the evidence that is not improperly collected is not usually admissible in the court of law and can cause a lot of problem by being that evidence being excluded in the trial. Now, after that, after you have collected that, then you do what we call acquisition, evidence acquisition. Now, evidence acquisition, as I said, is what we call, you duplicate the data to preserve the original data, which means that if I get a computer and that computer was off, it was not turned on, remember what we said, post-mortem forensics. Now, if that computer is off, it is not on, it is switched off, then I'll actually, the evidence that I'm looking for is actually residing on the hard disk. So what I'll do is I'll take that hard disk, I'll hook that hard disk into my forensic workstation or the computer that I'm going to use for analysis, and I'm not working on that original hard disk. What I do duplicate, I duplicate the original, which means that I do what we call disk imaging. What I just showed you a while ago with the right blocker, I do disk imaging. This imaging is creating a bit by bit copy of the content of the electronic evidence. So if it is one hard disk, I'll copy the full content of that hard disk into another media and then analyze that media, but so that I don't interfere with the original evidence. Because if you interfere with the original evidence, things can, before the case is over, something can come up and the other party says that, no, we need the original evidence so that we can also do the analysis, but you've already interfered with it. So it is important that you do this disk imaging, that is bit by bit copy of the content. Once you've done that, then you create what we call the hash value that we've looked at. So hash value means that this evidence, this duplicate copy, exact copy of the original, and it can be shown by creating that hash value. So if anything happens to the original hard disk, and let's say somebody goes and deletes evidence from that hard disk, Then by the time, if there's a dispute, you'll have the duplicate copy plus what we call the hash value, and the one which is changed, you'll create another hash value, and you compare that to the hash value that you created originally and with the ones which has been created after the change has been made to the evidence. Then you'll see that they are different. If they're different, you'll always know that somebody has interfered with the original evidence. So you use blocker to prevent the alteration during the copying process, and the integrity must be maintained. The examination process should be performed on the bit stream copy rather than the original. So you do not always interfere with the original. Create a copy, create a bit stream copy of that original evidence, and then you can analyze that bit stream copy rather than analyzing the original. Now, and this is what I showed you in the last slide. You can see that the black gadget device is the right blocker, and it is connected directly to the forensic workstation, which means that the computer that is used to analyze this particular hard disk. And this is the on the right is the suspect hard disk. So it's copying the content from the suspect hard disk into another media and then analyzing that media. This the hard disk on the right will remain original and you can make as many copies as you wish, and without interfering with the original data, because what you are going to analyze is the copy of this particular original. Now, if you are doing that, you need to take precautions to prevent exposure to evidence that may be contaminated with dangerous substances or hazardous material. All items submitted to forensic examination should be inspected for their integrity, and methods of acquiring evidence should be forensically sound and verifiable. Method, if you deviate from that anything, then you should be able to document that. Now, there's what we call during acquisition, you create, I've talked about creating the hash value. So electronic evidence must be submitted and maintained in such a way that integrity is preserved. Integrity is very important in the electronic evidence. I've talked about that more a lot. And any errors encountered during acquisition should be documented, and steps should be taken to ensure the integrity of the data acquired. This may include one of the following: that is doing the hash value, that is MD5, SHA1, SHA2, and then you need to store it in read-only media, and then seal in a tamper-proof evidence packaging, and take it for analysis. Acquisition types. There's two. There are what we call physical acquisition, in which case you use a hardware and software right blockers, this one you use to prevent writing to the original evidence. Then forensic images should be acquired using hardware and software that is capable of capturing bit stream of the copy of the original media. Then there is also logical, which means that hardware and software right blocker should be used to prevent copying to the original. And then forensic image should be acquired using hardware and software that is capable of capturing sparse or logical image of the original media. Sorry. Oh, this, my screen has frozen. Now, I talked about what we call live acquisition. Now, live acquisition is where you go up to a place and you cannot be able to carry that computer and go with it to the lab. For example, if you find that it is a server, or you go to a place and you find that by taking that computer, you're going to actually make these people not to work. We are going to make the operation to stop. So what you are forced as an investigator is to acquire data from a live system. So live data should be acquired using a hardware or software that is capable of capturing a sparse or logical image of the original. And live acquisition software should be run from a trusted environment to prevent unnecessary changes to the live system. And live acquisition software should be run at the highest level of privilege available to ensure that all possible data is copied. Here is a case where I've said you do not have the luxury to pick this computer and take it to the lab. You do not have the luxury to shut down this computer and get the hard disk. Also, at the same time, I say that sometimes you find that if you are investigating a malware, that malware is actually sitting in the memory. So if you shut down that computer, that particular malware code, binary, you will not be able to get it. So it forces you that you need to acquire or capture the live memory so that you can capture the binary of the malware. Also, sometimes there are even if it's not it's a laptop, but it belongs to a criminal. You know very well that these criminals always encrypt their hard disks. When they encrypt hard disks, which means that the moment they shut down that computer, you will not be able to shut down if you don't have the encryption key. So that is why it is important that when you want to do, you get such kind of computer and you suspect that it has got the data and this guy is a criminal, you need to do live acquisition so that you can be able to capture whatever is in the memory, because you'll find that the encryption key is also kept in the memory. Things like passwords might be in the memory. So live acquisition means that you are acquiring that evidence from a running computer when it is actually running. Now, what do you need to put in your document? When you are doing the documentation, what you need to put is you have to put your examiner's name, the acquisition date, the acquisition details, is the type of acquisition that you've done, which tools. You have to put the physical condition of the evidence and unique identifiers, that's such as the serial number, description, and model. These things are very necessary because when you are analyzing a device, you need to put all this information so that in your report, so that all the information is complete to show the court what you are actually doing. Minus some of this information, you'll find that that evidence lacks integrity. The integrity cannot be relied on. So this information must be included in your report when you are doing the acquisition. Now, preservation. Once you've acquired, you need to preserve. Now, the process to maintain and safeguard the integrity and of the original condition of the potential electronic evidence. So that is preservation. It is the process to maintain and safeguard the integrity. The integrity is very, very important in any electronic evidence. Electronic evidence is very fragile and can easily be altered, damaged, or destroyed by improper handling. So evidence preservation helps assure admissibility in court, and electronic evidence should be stored under strict access control to protect it from accidental and deliberate modification. So preserving this evidence is very important. Because by the time you acquire it, before even analyzing, you have to make sure that it is preserved in a way that the integrity of that evidence is intact. So preservation is just a way of ensuring integrity of that evidence is intact. Now, evidence management. As you can see in that diagram there, we have procedures. The procedures used to protect the evidence and document document when collecting and shipping. Things like it is like the logbook of the evidence. It gives you you have to give that evidence a unique identification, and you need to maintain what we call chain of custody. And because if that chain of custody can be proved in court that it was broken, then automatically that evidence is not going to be allowed in the court of law. Then if there's some sort of evidence transfer, then that also need to be documented. At the time of the evidence transfer, both sender and receiver need to give information and date and time of transfer in the chain of custody. And documentation is very important because handling and evidence, what you need to do is much of the documentation so that you are transparent of anything that you are doing. So protection is evidence management helps in protecting the true temperament of the device. Chain of custody. We've talked about previously on chain of custody. This refers to the chronological documentation or paper trail showing the seizure, custody, and control and transfer analysis and disposition of physical or electronic evidence. Why is chain of custody important? Chain of custody is important to show the integrity of that evidence. From the time that evidence was collected to the time the evidence is actually produced in the court of law. That chain of custody is important. And that is one of the documentation that will be able, the investigator will need to have and to accompany the evidence. To maintain the chain of custody, you must preserve the evidence from the time it is collected to the time it is presented in the court of law. And to prove the chain of custody, forensic investigators should testify that the evidence offered in court is the same evidence that was collected or received. And they should also testify to the time and date of evidence was received or transferred to another agency. Time is very important. Time stamp is very important. Time and date stamp when it comes to electronic evidence. Without time and date, I mean, it will be very difficult for that evidence to maintain the integrity. That there was, they also need to testify that there was no tampering with the item while it was in their custody. So a chain of custody should be initiated at the time evidence is recovered. The chain of custody begins as soon as the seizure takes place, and it concludes when the evidence is actually returned or destroyed by according to the order of the court. So that is in a diagram form. That's the chain of custody. A chain of custody is a legal document. So see here the fact that it is a legal document. So which means that it will have to accompany for this evidence to be admissible in court of law. This chain of custody must be able to accompany the evidence. So it just is a legal document that demonstrates that the progression of evidence as it travels from original evidence location to the forensic laboratory. So this chain of custody is a legal document. You need to have that in mind. So what are the functions of the chain of custody? It governs the collection, handling, storage, testing, and the disposition of evidence. It safeguards against tampering with or substitution of evidence, and it documents that these steps have been carried out. So chain of custody is something which is very important when you are presenting that evidence in the court of law. The chain of custody form should identify the sample collector, the sample description, type and number, sampling data and location, and any custodian of the sample. That's just a form of chain of custody. As you can see, there's a lot of data that you can capture there. And this is something very important for admissibility of evidence. Yeah. Now, once your evidence has been preserved and evidence before you present it, because you need to analyze that evidence or examine that evidence, that device to get the evidence. So this is what we call forensic analysis or forensic examination. So this phase requires that you use the appropriate electronic forensic tools and methods to uncover electronic data, which means that there are tools that you are going to use to do the forensic analysis. And these tools are many. Some are open source, some are commercial, and it depends on the jurisdiction. There are some tools that are preferred by the law enforcement and also will be recognized by the courts. But there are also some tools which when you use it, you need to use another tool just to verify whether your results are correct. So the type of electronic digital forensics tool vary depending on the electronic digital forensics investigation conducted. And I've just included that link that you can look at to see some of the forensics testing tool program that is been created by NIST. So conducting an examination on original evidence, media should be avoided as much as possible. I've talked about that, and making sure that when you are using these forensic tools, they should use the standards and best practice to establish validity and reliability of digital forensic results, which means that the forensic results that's coming out here must be valid, must be reliable. To be admissible, the tools and techniques used in digital forensics must be scientifically valid. That is, they should be proven to be accurate, to provide accurate results through empirical testing. And secondly, the digital forensic results must be reliable. That they must be obtained on different occasions using the same data and tools and techniques. And also the other thing which is very important for forensic analysis, the results that you get from the forensic process must be repeatable and must be reproducible. And this is when it will be actually be able to stand the test of the court. The results are repeatable when the same digital forensics results are obtained using the same test items, same equipment, same laboratory, and same operators, which means that I'm using the same test item, I'm using the same laboratory, I'm using the same the tester, the analyst. So that means that it will that means that the results are repeatable. Now, results are reproducible when the same digital forensics results are obtained using the same test items but different equipment and laboratories or operators. So a forensic process for digital forensic examination or analysis process is now the core, what will give you the evidence that you want to present in a court, and you have to prove that this is scientifically achieved. The evidence is scientifically achieved. Now, also, once you do that, you do your reporting, and the report should be clear, concise, and written for appropriate audience, which means that if you've done your analysis, you are the person who are going to present this report to the person who commissioned you to do. If it is a corporate environment, then you are going to present this report to the guy who commissioned you. If it is a law enforcement, then it is supposed to be to go to court. So you must make sure that the report that you are coming out with is clear, concise, and written for the appropriate audience, if it is whether corporate or law enforcement. So document the scope and purpose of the examination, why you are doing the examination, what was the scope of the project. Give a detailed description of the media examined. If it's a hard disk, make sure that you describe the hard disk, you put the serial number of the hard disk, they put all the information that is needed. Then documentation of each phase should be identified for it's relevant to the investigation, and you need to provide description of the evidence that was acquired during investigation. Provide examiner's name and date of examination. So what are some of the elements of a good report as an investigator? So as some of the aspects of good report is that a good report achieves its purpose by answering the questions that were set out in the mandate of or for the investigators. Now, it is also designed to meet the needs of the decision maker. So if it's a corporate environment, then the report that you are going to produce will be used by the decision maker to make the decision. So a decision maker must rely on the facts that were presented in the report, and the fact must be based on the evidence in the file, and it must be clearly written in a neutral language so that the decision maker and other readers will be able to understand it. Don't use jargon when you are doing your forensic analysis report. It should be concise and must convey the necessary information, and it should be structured in such a way so that information can be located easily. So if you meet all this, remember the steps that we've talked about. What are some of the challenges that when you have the electronic evidence, you'll experience these challenges. Once you follow the process the way we've seen in the slides, it will make you have or come up with the evidence that will be legally admissible in court when you presenting before the judge or the decision makers. That brings me to the end of this presentation, and I can give back the floor to Gigi.
Thank you, Lawrence, for a very insightful, yet again, presentation. Before we get to everyone else, if you could just go back very briefly to the issue of disk imaging.
Yes.
How foolproof is it, Lawrence? I mean, can it be tampered with? Can you even prove that it's been tampered? How exactly is that situation, please?
Okay, when I talked about disk imaging, because one, where the place that you'll find evidence in a computer is the hard disk, okay? Now, if that hard disk has got evidence, it has to be protected properly. So before you start analyzing that evidence, remember what we say, that do not work on the original evidence, okay, or do not original device. So why you are doing this imaging is because you want to preserve the original evidence, but the original disk, but work on the duplicated copy of the disk. So you remember what I said, that the electronic evidence, evidence can be device can be duplicated several times, and the copy will just be the same as the original. So what happens that with disk imaging is a scientific process, and don't worry, because you'll use a device to do that disk imaging and create what we call the hash value. So the reason why you are creating that, as I said, is because you want to analyze the duplicate copy. So what this imager will do, it will copy the content of the original hard disk into a different media. And once it is copied, it calculates what we call hash value. Hash value is just a mathematical function that it performs on the original and the duplicate, to ensure that the original and the duplicate are exact copy. They are similar. They are identical. So they are what we call the hash value will prove that. the hash value will prove that the two copies that have been created, the original and the duplicate, are identical. So should anything change on the original, then you'll be able to see that the hash value will change. So if you suspect that once you've done the duplication, the bit stream copying of the original, and you've created a duplicate copy and created a hash value, and you suspect that the original has changed, somebody maybe went there and deleted the evidence from some file from that particular hard disk. Then when you suspect that, you just take that hard disk which has been changed and you create another hash value. Once you create that hash value, you compare the hash value that you've created as at that time with the hash value that you created originally when you are doing the first imaging. And if the original has changed, these hash values will be different. So that is how you maintain the integrity of the original. Don't know whether that answers your question.
Yes, very eloquently. Thank you very much, Lawrence. Now, if I would like to invite people to raise their hands who have questions for Lawrence, please. Does anyone have a question for Lawrence? A comment? While we're waiting for people to raise their hands, I'm going to read some of the questions in the Q&A, Lawrence.
Yeah.
So the first question is, what is checksum in relation to preservation of digital evidence?
I think I've explained that. Checksum and hash value is something similar. What comes out is it is what we call hashing algorithm that creates a value that this value can be is a long string of numbers and alphabets. Now, this value is called hash value, or it can call message digest, or it can be called checksum. It's just to maintain the original, that the integrity of the evidence has not been interfered with. And if it is interfered with, the checksum or the hash value will always change.
Okay,
Yeah.
Thank you, Lawrence. I have another person here. They're saying they're a little bit confused, and they would like you to rephrase what a hash value is and how it's created. Could you put us through that again, please?
Okay, let me explain it in another way.
Yes.
We know that we use information to make decision. Okay. Now, information, by the time you are creating information, you know that this information is known to be good and nobody has interfered with this information, right? So once I create information, let's say I create a Word document, I save that Word document and I save it in a network folder where other people have got access to it. Okay. So once I save it there, and it takes let's say sometimes, and I want to go back to that document and use that document to make a decision. Okay. What do I need? I must verify that document that I created is still the same. Nobody has interfered with it. Because if somebody has interfered with it, then I'll be able to make a wrong decision. So what I do is, by the time I'm creating this document, okay, once it is known to be good, I create what we call hash value. Hash value is use technology which is called hashing. Hashing is just a mathematical function that I apply to that document. And the result that it produces is what we call hash value. Now, hash value is a string of numbers, and it is a fixed string of numbers using the techniques that I mentioned there, the MD5, the SHA-1 and SHA-2. Those are the hashing algorithms. Those are the techniques that you use. So what I do is that once I create that hash value using the maybe technology of MD5, I create that hash value out of that original document. And I save that document in a network folder. then somebody maliciously goes and changes that document. By the time I want to use that document, I download that document, and then I do another hashing algorithm and create a new hash value. Then I compare the hash value which I created when the document was known to be good with the hash value which is now which I've created when I want to use the document to see whether somebody has interfered with the document. So if the hash value are different, then I know that the document has been changed. If the hash value is the same, then the document has not been changed, and you can rely on the document. The same technique is what we use when we want to verify that the contents that I'm creating out of our original hard disk with the duplicate media that I'm going to create out of it, are they the same? Okay. So what I do before I do anything on that particular hard disk, I take it through the hashing algorithm using those techniques, SHA-1 or MD5, and then I create the hash value. Okay. Now this, don't worry, because the gadget that you are going to use to do the duplication will automatically create this hash value. So it is not something that you do on your own. There is a forensic tool that you are going to use to do the duplicating, will actually create that hash value and then store that hash value to show the integrity of both the original and the duplicate copy. That is, they are identical because they have the same hash value. Okay. I don't know whether that explains it.
Yes, it does, Lawrence. Very well. Thank you. The next question is, what are the red alerts to watch out for when challenging electronic evidence in court?
Okay. It depends on the investigation and the person who did the investigation. But someone like me, if I go to court and of course what I'm going to be given if I'm on the defense side as an expert witness is the report that the other party has done. So as an expert witness, I'll be given that report, and then I'll look at those the report and pinpoint some of the things that are not done properly. But there's no direct answer, but it also depends on the person who did the investigation. Because, for example, I'll just give you a practical example what I experienced. I went to court, and once I read the report, I pinpointed a lot of the loopholes in the report. But one of them, which was very, very, very visual, was when these guys did produced the evidence and wrote transferred the evidence on the CD. First of all, there was no documentation. So in the absence of documentation, proper documentation and chain of custody, you know that the integrity of that evidence cannot be relied upon. Secondly, these guys broke the chain of custody. Remember, I said that the chain of custody should not be broken. So they took their device that they used to do the investigation, they brought it to court, and then later on they came and took it back, saying that it had got some other evidence which is not related to this case. So that is also that also brought some integrity issue on the evidence that was brought in court of law. So then the process itself, the process was flawed, because when they took this evidence, they took this device. The device had no name. The device had no manufacturer. The device had no information about the manufacturer, no information about the serial number. So we don't know what kind of device was used to do this investigation. So that also cast doubt on the integrity of the evidence. Now, how the process of taking that device and transferring that evidence from that device to the CD that they brought to court was also opaque. There was no documentation about that. So that was also another loophole. The evidence itself had got different dates. the case was in 2018 that evidence was reading, the video that they brought was reading 2014. So that was also another loophole. So I cannot pinpoint that these are the red alerts, but it depends on the situation, on the investigation itself, and the guys who did the investigation, and even sometimes it even borders into the qualification of those guys. Yeah.
Thank you, Lawrence. So I'm getting a lot of comments about the availability of your contact information. Will you be able to provide that to our listeners?
Yeah, just a moment. And Gigi? Yeah, can you see my telephone number there?
Oh yeah, perfect. So everyone who is in this webinar, if you could take a screenshot of Lawrence's email and phone number, please, for those who are asking for his contact information. On the same level, Lawrence,
yeah.
I have someone here asking, are you or your organization available to be called upon to either validate or counter digital evidence that is presented in court?
Yes, I'm always available. There are certain things I've worked in across East Africa, so my availability is always there.
Perfect. I also have questions and comments about the slides for the webinar, for the first part and for the second part. I understand the Secretariat is going to make those available to the people that are present.
Yeah, I think that one, I think that's
Gabriel?
up to the Secretariat. Yeah.
Gabriel, are you there? Hello, Gabriel.
Yeah, Gigi, these slides will be available to members. So
Perfect.
we shall share them along with the recording. Thank you.
Thank you so much. Thank you. So at least that answers that question. Lawrence?
Yes.
The next question, I think this is something you might have answered in the first part. It says, where do we find rules that regulate the collection of electronic evidence?
That depends on the jurisdiction.
Yes.
And like in Kenya, we have the Evidence Act. And the Evidence Act, we have, I think, Section 78, which is talking about presentation of texts and WhatsApp evidence. And then we have Section also 106B, which is talking about the certificate that accompanies evidence when you are presenting in the court. So that depends on, I can't say these are the ground rules, but it depends on each and every jurisdiction legislation.
Thank you, Lawrence. Thank you. Right. I have another question with regards to the hash value. It says, can anyone create a hash value, or only an expert can do that?
No, anybody can create a hash. I wish we had sometimes I could have shown you the how to create that. Anybody can create a hash value. If you go, there are certain sites. There are certain sites that you can go to and be able to create a hash value for any document. I don't know, Gigi, I would have prepared that early. I'm sorry about that. But yes, anybody can create a hash value. Maybe in the, just share with you a link, and then you can share this link with people so that they can see how they can create hash values.
Thank you. Perfect. While we're waiting for you to share the link, do we have anyone who would like to raise their hand to ask Lawrence a live question, please? I don't see many hands today, Lawrence.
Maybe everybody has understood everything, or they have not understood anything.
No, I think they've
either way,
understood.
they have understood or not understood?
No, I think everybody understood, especially since this is a session 2.
Yeah. Okay.
Did you share it on your screen?
No. I'll just, I need to check my computer where the application is,
Okay.
then I'll share it with you.
No
I'll
worries.
share it on email.
No worries. I have no more questions on the Q&A and no more comments on the chat, apart from the ones that I've already touched on. And I have no more raised hands. I don't have any raised hands. Is there anything else you'd like to tell us as a closing, Lawrence, please?
What I can say is that for lawyers, we need to really be up to date with the technology, because nowadays I don't see any case that will not involve electronic evidence, because most of these cases that come will find that the evidence is derived from an electronic device. So you need to analyze that evidence, but also what is important is that why you should have this knowledge is that when the expert presents the evidence, electronic evidence, then you should know what it is and how you can counteract the arguments that they are put forward by the expert. I'm saying so because I've gone to court several times as an expert witness, and both on the prosecution as well as defense, I rarely get any questions, especially when I'm on the defense side. The prosecutor will not ask me any question that is relevant to what I'm actually trying to present. Likewise, if I'm on the prosecution side, I hope that the defense attorney will come up with the questions that are relevant to what I'm presenting, and in most cases, I find that it is very, very rare. So this kind of knowledge is really needed for lawyers, so that you can be able to understand how electronic evidence is supposed to be presented, and what kind of questions you can be able to prepare for the expert, so that you can win the case. Yeah, that's it. I don't have any other thing apart from that.
Thank you. Thank you so much, Lawrence. I'd like to thank you very much for a wonderful and thought-provoking presentation. Again, we're very grateful to have you.
I can see another question here. I don't know whether it's a question or is a comment. Meaning live acquisition is the best. Yeah,
I must have missed that one. Thank you. I must have missed that one.
Now,
yes,
yes, I wanted just to comment on that. Now, when it comes to live acquisition, I think in most cases, you'll find that this is what we call incident response, digital forensics incident response. You find that most of the attack nowadays, especially they attack you using ransomware and things like that. Now, when somebody attacks your computer using ransomware, it is rarely that code of ransomware, the binary is rarely copied into the hard disk. It will be run from the computer's random access memory. So which means that if you shut down that computer, you will not be able to get the binary, and you cannot be able to analyze that particular malware. So yes, live acquisition is always good if you find a computer which is on, and before you shut it down, then you need to collect what is in the memory so that you have that evidence, because a lot of things will be found in the random access memory. Just remember, a random access memory can be as much as 8 GB. So if you shut that computer down, which means that you are going to miss 8 GB worth of evidence. So live acquisition is always good to be done on a live system before you shut it down. Yeah.
Great.
Go ahead,
Thank
go
you.
on.
Thank you,
Yeah.
Lawrence. Thank you. Can I ask, will there be a part 3 that we can look forward to?
We need to discuss with the secretariat, but I think our initial agreement that they were supposed to do be 3 sessions.
Okie dokie. Thank you
Yeah.
so much.
Yeah.
As I was saying, thank you for a great presentation. We're very grateful to have you, and we look forward to more sessions with you. Gabriel, if I can take it back to you, please. Gabriel, can you hear me?
Yes, Gigi, I can hear you loud and clear, and
Thank
I
you.
would like to thank you so much for steering this conversation this afternoon. It has been quite an informative presentation, and I'm sure that our participants have been and on behalf of the Secretariat, would like to thank you so much, Lawrence, for your presentation. It was quite an honor to have you on the panel, and we know that your time is really precious. And for that, we are immensely grateful that you're able to carve out some time and share with us your wide knowledge and experience in this area. We thank you so much for always being there for us and the membership. And on behalf of the whole team, once again, Gigi, Lawrence, and the participants online, thank you so much, and we wish you a very blessed weekend. Watch out for the 3rd session. We're going to engage in more conversations on that, and we'll have another quite impactful session. So thank you so much, and have a lovely weekend.
Thank you. Bye-bye.
Thank you, Gabriel. Thank you so much, Lawrence. Have a nice weekend.
Same to you, Gigi.
Thank you. Thank you to all the participants. Have a nice weekend, everyone.